Welcome to Inventive Minds Child, Youth, and Family Support Center. We are a not-for-profit organization working with families in their day-to-day parenting by providing workshops and seminars related to pediatric and child development. Inventive Minds provides care in the early years sectors for newborn to age 6, licensed under the Ministry of Education all across Ontario. Inventive Minds carries an elementary school open to international students from junior kindergarten to grade 3. The Inventive Minds Family Center helps families in mediation, arbitration, and parent coordination cases related to family separation and divorce. We support families during and past separation and divorce. Inventive Minds works with court orders to conduct child voice record and parenting courses related to CAS, court, and mediation purposes. To learn more about our services, reach us at inventivekids.com or canadafamilymediation.com. Hello, I'm sitting today with Mr. Clayton Spencer, who is a lawyer and an arbitrator. Our topic is about family mediation and arbitration and the benefits of both.
Thank you. I'm thrilled to be here today to talk about mediation and arbitration. I've been a lawyer for about 27 years now. I've been practicing family law throughout. My practice is situated in Durham region, and so a lot of the things I'm going to talk about today are based on my perceptions from where I practice. I've been an arbitrator for about 9 years now. It's certainly an interesting field to be in. One of the things that I now do is I'm co-chair of the arbitration section of the Ontario-based FIDRIO. We have a meeting once a month typically, and myself and some of my arbitrator colleagues sit down and we discuss recent events, interesting case law, problems that have come up in arbitration practice. In addition to being an arbitrator, I'm the chair of the Walsh Family Law Moot. So back to you.
27 years of experience in the field. I can imagine the number of files you had to work with. And
roughly 1,000, give or take.
Wow. So I'm going to ask you some basic questions. I realize these are more for day-to-day parents and families that might be listening to our podcast to just understand a little bit more about the benefits of mediation and arbitration compared to court and litigation process. Although those are also very important in certain cases, but we want to more talk about general mediation and arbitration together today. So would you mind explaining to us what is mediation?
Mediation is alternative dispute resolution method. We often call ADR. If and when I use that phrase today, just remember we're talking alternative dispute resolution. In a mediation, a neutral is hired in order to assist the parties to come to a consensual resolution of whatever their dispute might be. In the family law context, their dispute might be about parenting or a support issue or division of property on separation, something like that. The mediator comes in, works with the parties together to come about with resolution. I find that a lot of people think that when they have a family law related problem, the only thing they can do is go to court. And that's absolutely not true. A very healthy percentage of family law disputes never see family court at all in Ontario, typically in a separation agreement. And mediation, of course, is one way to negotiate the terms of a separation agreement. It's a way of making that deal.
So it's more being unbiased, helping families resolve their conflicts.
Indeed. The person who's doing it has to be neutral. Now, there are other ADR methods out there. Collaborative practice is a good example of this, where, yes, there are neutrals who are often involved, but you also have a lawyer who's directly involved in the process, who's assisting the parties directly. But that's not what the mediation model is. It's having that neutral person. Typically, it's one person, but it can be more than one. Sometimes people do it in a team model to help the parties come to that agreement.
When we talk about team model and when we talk about collaborative, can you tell me what are those extra supports that are beneficial to the families as part of their expertise team?
I should just say a little bit about collaborative so that we're distinguishing it from mediation. The collaborative process is, again, a different method of getting to an agreement. In the collaborative model, the parties will sign a collaborative participation agreement, and their lawyers will sign it too. So the lawyers parties have are committing to that process as well. One of the hallmarks of the process is that the parties are agreeing to not go to court, and the lawyers are agreeing not to go to court. Collaborative these days is usually done in what they tend to call the team model. And in the team model, the underlying premise is that the lawyers don't have all of the skills necessary in order to assist parties to get to a resolution. I will absolutely agree that they don't teach a lot of those skills in law school. We often have financial neutrals that are brought into the collaborative process. We often have parenting persons who are brought in who have special training and expertise in parenting matters. We will often have mental health professionals brought into the collaborative process. And all of those sorts of people are neutral. They're there to help everybody to come to a resolution. There are so many professionals these days that I'm aware of that have collaborative training and can be brought into those sorts of processes, including mortgage brokers, real estate agents, folks like that. One of the reasons why I like collaborative, and I've been collaboratively trained for 17 or 18 years, is because it's very supportive. And although mediation is certainly a supportive way of getting to a resolution, I'm going to suggest that collaborative is probably on average more supportive because you've got different professionals and people with specialized expertise to help you out. And although I try and be all things to my clients as least as much as I can, I'm certainly not trained in mental health issues or especially trained in parenting beyond being a parent myself. Having access to these sorts of people can be quite helpful.
I have to agree on that. I am also a mediator and I do collaborative parenting experts. I can see how both of them can be really beneficial process depending to the family situations and what is best for the family.
Oh, absolutely. It's essential to understand what your options are. The idea, of course, is to try and pick the option that suits their needs the best.
Exactly. Would you mind explaining to us a little bit about what makes arbitration effective?
Arbitration is another ADR process. And arbitration involves hiring a differently trained neutral. So arbitration training is different from mediation training. Arbitrators can decide all matters that a family court judge could decide. Unlike a mediation where the mediator is working with the parties in order to come to consensual resolution, an arbitrator is going to hear from both of the parties, hear evidence, hear their submissions on the law, and decide one or more family law issues and come to a decision, not unlike a family court judge would. For the vast majority of people, an arbitrator will have broad enough authority to deal with all of their family law issues. Now, another hallmark of arbitration is that it's contractual in nature. The parties to an arbitration sign a contract which sets out the issues that the arbitrator is going to decide, and it's that contract that establishes an arbitrator's jurisdiction. This is really important for us arbitrators because if we get hired and our arbitration contract says we're here to decide a parenting issue, halfway through the arbitration, one of the parties can't just pop in a support issue and say, oh, we'd like you to do that too. Now, it could be added later on if the parties agree, but I can't stop an arbitration halfway through and say, oh, we're just going to add this other issue too. Arbitration is a really flexible vehicle for dispute resolution. Depending on the issues to be decided, you might not even need to have an in-person hearing. And that's one of the reasons why people choose arbitration. It tends to be a lot less expensive. There is another process that I should mention before we get on to perhaps benefits, and that's mediation arbitration, or MedArb for short, which is a hybrid model. And it mixes a lot of the good things about the mediation model with the arbitration model. In a MedArb, it still starts off with a contract, but the arbitrator first acts as a mediator. He or she is going to try and help the parties to come to a consensual resolution. If that doesn't work, the parties will go on to an arbitration stage. Typically, a pre-arbitration planning meeting occurs where the arbitration itself is planned out and ultimately an arbitration happens, decisions made, and an award is issued by the arbitrator. The advantage of the mediation arbitration process is unlike a straight mediation where you have to agree at the start to use the process and you have to agree at the end what the result is. In a MedArb, you only have to agree to use the process because you will get a resolution. There are MedArbs that specifically have an opt-out provision built in. But for the vast majority of these things, once you're in the process, you are in the process. If there's no consensual resolution at mediation phase, you'll have an arbitration, you'll get a decision.
When should someone choose to arbitrate?
People should choose to arbitrate with more frequency than they actually do. I think most people don't know that arbitration exists, including some family lawyers, by the way. It tends to be not widely used. Toronto is an exception to that. Arbitrations tend to happen a lot more quickly than a standard court process. Another benefit is confidentiality. The family court is open court, just like any other public civil court in Ontario. Although there are some rules now about allowing third parties access to files, they still can. And that means that any adult person in Ontario could read your court file, including your children when they grow up. You don't necessarily want to create a public record. And of course, where people have more sensitive issues to discuss, businesses, for example, you might not want that information being in the public record. Cost is another reason why people choose to arbitrate. The family court, in my experience, is still the single most expensive option people can choose when they separate. But because arbitration processes tend to be faster, and because you can tailor them to the individual needs of the case, even though you're paying for your arbitrator, it still tends to be less expensive than the court process, even though you're not directly paying the salary, of course, of your family court judge. Flexibility is another reason why people will choose to arbitrate. The family court process tends to be a one-size-fits-all. For example, if you want to change a court order, there's one form you have to fill out, and it's geared to all sorts of motions to change final orders. But you may have one insular issue and not really need to fill out a whole bunch of stuff. And so you can save a lot of time and effort and work choosing to arbitrate it. In my opinion, for what it's worth, I don't know why anybody brings motions to change final orders anymore. They're just so slow, not very cost effective. The mediation arbitration model is much better suited to an issue like that.
I'm sorry that I'm jumping in because I so much agree with you. Sitting in a school setting and working with families, I find that through litigation, parents seem to become more angry and more bitter. It can actually raise domestic violence when you go through the litigation process rather than going through a mediation arbitration, because it's more family focused, child focused, and it helps the children and families to continue having some form of positive relationship. Where if you put it through a litigation process, children will be affected longer in it. It can actually become more traumatic for the family rather than an easy process to move forward.
I should mention a couple of follow-up points based on what you've said. One of the things that's the most difficult for people to go through, in my opinion, is not necessarily the decision to separate. That's difficult for sure, but I think it's more difficult to go from that decision to having all of the personal, legal, other details addressed to get you to that next stage in your life. And when you consider that a typical family court process in Durham Region, so I'm talking about Oshawa Family Court, will take more than a year to resolve. And in other jurisdictions in the GTA, like Brampton, for example, will take much longer than that. I know of lawyers who practice out of the Brampton court who want to file a motion, and it takes the better part of a year to get that motion heard. And that's just a motion. That's not a trial. So very, very slow. It leaves a lot of loose ends. When people are in that limbo in between the decision to separate and getting things resolved, tensions tend to rise. Statistically, one of the most dangerous times, if not the most dangerous time for spouses who are separating, is just before and during that period of time when that separation's happening. If we as a society accept that people are allowed to separate, we need to get these people onto that next stage of their lives in a safe way, in a humane way, in a way that's attentive to their needs. The last thing I want to say about why you should choose arbitration, and that's the attention that you get. If you're in the family court on any given day in the family court for, say, a settlement conference, you're probably on a list with 8 other cases. What that means is you're not going to get all of the judge's attention that day. The judge may or may not have read your materials, but if you come to a MedArb to have a session to discuss the legal issues that have arisen, you're going to get all of your arbitrator's attention. The arbitrator is going to have read all of the material ahead of time and is going to come ready to go. Don't get me wrong, I'm not suggesting that family court judges are unwilling to do the work. The vast majority of judges I know, and I know many family court judges, are very dedicated to doing a good job. but they don't have the luxury of time. Your arbitrator or mediator arbitrator has more time to put attention and thought to your case and deal with the details that often we don't see in the family court. The attention that you're going to get is another essential element of why people should choose arbitration and mediation arbitration.
When you go into the litigation process, when you are sitting with the judge, do they all have family law background?
The short answer is you can never be sure that your judge has a family law background. Some jurisdictions have dedicated family courts. Us lawyers call them unified family courts. By both levels, I mean the Superior Court and the provincial level. And those judges who sit in those UFCs are appointed to that position specifically. But even in those jurisdictions, you might on occasion see a judge who's a generalist, maybe dealing mostly with commercial matters, general civil litigation, but for whatever reason, maybe a judge is sick that day, they've been plonked into the family court. You can never be certain that the judge you're going to see has a family law background. I've certainly appeared in court on my own matters to be greeted by a non-family law judge. And again, most of them are going to try really hard to do what they need to do in order to help people along. Unfortunately, you're not getting a specialist anymore.
So those are all benefits of mediation and arbitration that we're talking about. And I think that is something that they are mostly unaware of at times. So I'm glad that we sort of brought that up. Mike, next question. How does an arbitration process look like?
The first thing you need to do is to figure out who you want to have as your arbitrator. There are different ways to do that. Sometimes lawyers will circulate lists of potential arbitrators and ask the other party to choose one. You should always look into who your arbitrator is going to be. Who is this person? What's their background? I'm happy to answer those questions. I have a CV that I'm happy to give to counsel or a party for that matter. I think most of my colleagues will act similarly. The next step is to sign an arbitration contract. This is not a short document. Arbitration contracts over the years have gotten longer and longer, and that's because us arbitrators have spent more time in arbitration figuring out what needs to get established ahead of time. So these contracts tend to be rather lengthy these days. You always want to have this contract reviewed by a lawyer who's familiar with such things, of course. You want to have a lawyer at this stage who's going to explain the legal effect of the contract, answer any questions about arbitration process that may not be spelled out in the contract itself so that you understand what you're getting into. Now, before an arbitrator accepts the matter, you have to do screening for domestic violence and power imbalance issues. In arbitrations, a third party, it shouldn't be your lawyer, has to do the screening. The screener should be properly trained. Typically, that training is 3 days of intense training. I've done it. I can tell you it's rather intense. There should be one screener who screens both parties. Once screening is done, the screener is going to send a report to the arbitrator, and the arbitrator is going to use that report to determine whether or not the matter is suitable for arbitration. Sometimes, before an arbitration contract is signed, I will hold a short meeting with the lawyers in the matter to discuss any questions they might have about the arbitration and the contract as well, for that matter. At that meeting, we can also discuss some of the issues over which there's some choice. For example, appeal pathways. All arbitral awards, just like court orders, can be appealed. But there are different potential ways to appeal and what issues can be subject to appeal. That has to be selected as part of the arbitration contract. After the contract is signed and the matter is accepted by the arbitrator, typically the next thing that's going to happen is a pre-arbitration meeting to prepare for the upcoming arbitration. Dates, deadlines, all of that stuff is going to be confirmed. Process issues are going to be determined. If motions need to be brought for disclosure, for example, that sort of timing is going to be discussed and fixed. This can be one meeting, it could be several, depending on how complicated the matter is. As for the arbitration itself, that's very flexible. Some arbitrations look an awful lot like a court proceeding, with the arbitrator sort of in the judicial role. There will be lawyers who are examining and cross-examining witnesses, but not all arbitrations require that level of process. Some arbitrations are done completely in writing. There's no in-person hearing at all. Just written material gets submitted to the arbitrator reads the material, makes a decision. And you can have lots of shades of gray in between the two. I did an arbitration about a year ago where all of the evidence was submitted in writing on affidavits, but counsel appeared before me for a couple of hours to make oral argument. It was eminently appropriate for the issues we had in that case. So the arbitration hearing itself can often look very different. But one of the advantages, of course, of picking a process that has less in-person talking time is that those processes tend to be less expensive. Oral evidence is one of the slowest ways of giving evidence. I'm constantly amazed at how slow that can be sometimes. The more you can narrow that, the faster the proceeding will be, and therefore less expensive. Now, a lot of arbitrations are done on Zoom. The use of Zoom breakout rooms and so on can be helpful sometimes in that regard. Arbitrators tend to charge a lot more per hour than I do in Toronto. If you happen to be in Toronto, these days, if you want to use Zoom, you can hire an arbitrator who's outside of the main city, who's going to charge you less for the same sort of thing.
I think a lot of people actually don't really necessarily like to sit in the same room together.
Mm-hmm.
They're going through that separation and divorce, and they prefer to have each other in a separate room, even if they're sitting with each other on Zoom rather than in person. And that's something I have actually experienced as well, working with families. That's what they prefer to do rather than sit in the same room and communicate in
Oh, for sure. The screener might recommend that the parties not be in the same room at the same time. Zoom can help facilitate that. So part of the benefit of arbitration is getting that information and, again, being able to tailor the process to the needs of those parties. It's going to make it easier for those parties to coexist in the same process.
Exactly.
Now, at the end of the arbitration, once the hearing has happened, the arbitrator is going to put together an award. That's a written document, and it's going to set out what the decision actually is and how the arbitrator got there. I just issued an award yesterday. It was 19 pages long. I try not to do overly lengthy awards. That hearing took the better part of 6 days to do. The award itself, as I mentioned, is potentially appealable. I'm not going to get into appeals today, but for the purposes of your listeners, I think it's important for them to know that an arbitrator's award is always appealable, at the very least, in case there's an error of law. If the arbitrator somehow misapprehends the law, applies the wrong legal test, something like that, that award is appealable. And the appeal goes to the Superior Court of Justice or your local family court, depending on what jurisdiction you're in.
We also briefly discussed that with the arbitration process, you can have your own legal representatives next to you, or you can also
Absolutely.
Arbitration without your legal representative. Those are big rights that people have. Is there something addition you want to add on to that, or are we good with that question?
It's absolutely recommended to have counsel when you're doing an arbitration, whether it's a med-arb or an arbitration straight up. Always a good idea to have a lawyer. Family law is quite broad. It's one of those areas of law that borrows a lot from other areas of law as well. It's not always as intuitive as you might hope for somebody who's not legally trained. In the arbitration process, you absolutely positively need a lawyer in order to review that arbitration contract before you sign. I do not take on matters as part of the arbitration contract. There's an ILA certificate, that's independent legal advice, ILA, that's been signed by a lawyer indicating that they've explained the arbitration contract to that party. Now, after that initial stage, somebody could self-represent. I've got a matter right now where two people are self-representing. Now, they did have lawyers at the start. I think for mostly financial reasons, they've decided to dismiss their counsel. I don't necessarily think that's a great idea, but they did. And you can do an arbitration with self-represented parties. It's a little more challenging because I can't help somebody advocate for their case. I have to remain neutral, just as a family court judge does. I can try and point them in the right direction. I can say that this particular issue is governed by a certain section of the Family Law Act. But other than the most general of assistance, I can't help somebody to frame their case. Now, if you're in a med-arb, once you've signed your contract, you could theoretically do the mediation on your own without counsel. But if you do come to a resolution, you should absolutely take that deal to a lawyer and get, again, independent legal advice, because you need to understand not just what the words on the page mean, but what the implications are. And sometimes there are implications that aren't readily apparent from reading the document. In fact, the arbitration that I just finished was all about things that weren't really apparent during the initial family law stage that these people had. So they ended up coming to see me for round two.
Thanks for explaining the importance of the independent legal advice. That's very important, and making sure that the process is protected for all parties involved to make sure that they make
Absolutely.
the best decision.
Well, there are lots and lots of different ways of resolving family law disputes that are quite acceptable. There are even some where you might question somebody's decision to bargain away a right to something, but people are allowed to do that. Ontario is a permissive jurisdiction. I've had people say to me, I know you're going to tell me I'm entitled to spousal support, but I don't want it. It's not my job as an arbitrator or a lawyer to impose spousal support on somebody like that. But it is my job to make sure that they're aware that there's a potential claim. And so when you're involved in any legal process, you need to know what those claims are, the strength of the claims, ideally before you sit down to bargain, but certainly after you've got the structure of a deal, you need that input.
I know we're short with time, so what takeaway would you like to leave us with today?
I'm going to come back to a comment I made at the start. In my opinion, arbitration remains underused in Ontario. When you consider how burdened our family courts are right now, and how expensive the family court model is, and how slow they are as a result, more matters should be brought into arbitration and mediation arbitration. It's really hard to argue about a process faster, less expensive, where you get a result that's more fine-tuned to the circumstances of your own case. In my opinion, benefits far outweigh benefits of going to court. There are some cases that do need to go to court, but that's one of the reasons why we do screening again, is so that the cases that do need to go to court don't inadvertently end up in an arbitration process.
And I think those are things that we need to bring more awareness in our community for families to know that when there is that conflict in the home, there are other ways to resolve the conflict that can be less time, less expensive, and support the family in moving forward.
Absolutely.
And I really appreciate the time you put with us today, and I look forward of our future discussions that we will have together as a team. Thank you so much for today.
Well, thank you, Rose. It was great to be here.
Thank you for joining this Inventive Minds Child, Youth, and Family Support Center workshop. Do visit www.inventivekids.com, kids with a Z.com, to learn more about the many other workshops available coming up soon. You can connect with Inventive Minds via email at inventivekids, again with a Z, at gmail.com for any parenting challenges so their professional team can connect with you. Check out a replay of this and many of our other podcasts by searching Inventive Kids on YouTube and the Parent Toolbox on Spotify. And join the Parent Toolbox Facebook community group today by searching the Parent Toolbox on Facebook. And we look forward to seeing you all again very, very soon.